Hi, David Blacker here from Air Gigs, and I'm here with Erin Jacobson, a music attorney from Beverly Hills, whose clients include everyone from Emmy Award winners to Grammy Award winners, independent artists, music publishing companies, record labels, and beyond. Erin's also the founder of Indie Artist Resource, which is a website that provides business and legal resources for independent musicians. So we're really psyched to be able to have a moment with Erin here today to kind of go over some of the more common questions that come up related to intellectual property rights. So thanks for taking the time, Erin.
My pleasure.
So I thought we'd start right at the beginning, real basic. When is the appropriate time to for an artist to register their songs with the Copyright Office?
My advice, and again, this is not legal advice, I have to state that ahead of time. This is for informational, educational purposes and does not create an attorney-client relationship. But when you want to put your music out into the world, you should register it for copyright, just because registration comes with certain benefits that you don't get if you don't register it with the U.S. Copyright Office, and the registration is the definitive date of creation that a court will look to. So I always recommend registration.
So if I'm an artist and I've just written a song and it's not really produced, at that point, create a scratch recording of that song and then use that to submit to the copyright registration?
The Copyright Office is going to look to the specimen that you submit, the deposit copy they call it. So you actually want to submit what you want to protect. So at that point it might be a little bit too early, but you should register it before you release it or something like that, unless you are potentially concerned about infringement with collaborators and you want to register an unpublished version and then register the version that you're going to publish later. But that does involve more than one application.
So you can update an application?
Yes, you can base an application off a previously registered work.
Okay, very good. And what about the notion of poor man's copyright, like the old school notion that you can kind of take a recording, put it on a physical medium, seal it in an envelope, mail it back to yourself, and it's postmarked, so then you can kind of use that as evidence, or the idea that you could use that as an evidence for when the song was written. Does that hold any water? Did it ever hold any water? Or?
Not really. It is some evidence, but again, a court is going to look to the date on the federal copyright registration, and that's the best date to go by.
Okay. Very cool. So just in a broad sense, can you talk to the circumstances where an artist might use, say, a production agreement or a work for hire agreement or a co-writing agreement? In what circumstances do those agreements are relevant?
When do they come into play? So a producer agreement's going to come into play when you are working with a producer. If you're an artist working with a producer or a producer working with an artist. And a work for hire agreement is when you're hiring somebody to contribute to your work and you want to make sure that you own everything that that person is contributing. And a co-writer agreement, what I like to call a songwriter split agreement, should be used any time that you are co-writing or sharing writing credit or splits with someone.
And at what point does it make sense for an artist to engage the services of someone like yourself?
Whenever there is a contract in front of you, or you need a contract, or there are things about the legalities of the relationship that you don't understand, because there's a lot of misinformation out there, and it's always best to speak to an experienced music attorney that deals with these issues, that knows how to advise you properly.
And then as far as remote production, which is kind of our world, do you see anything different that music creators and producers need to consider before engaging session musicians on a remote basis?
It's not that different aside from the location, but there are a few instances such as the venue that the contract is, what law the contract's going to be governed under. So if someone's remote, they might have to travel if there's some sort of breach of contract issue, as well as if you're writing something and then hiring somebody remotely to contribute to it, it's probably not going to be considered a joint work. So that's something that you want to consider as well.
That makes sense. How about just some, from your years of experience, what are some of the real common pitfalls that you see with respect to legal issues that arise with artists?
So on the registration side, it's usually improper registrations or not registering the work, because then later there's usually some problem between collaborators that might prevent a proper registration. But the most common is really the contract issues, where people are not contracting with each other at the time that they're working together. They are writing together, they're not deciding the splits, they're not putting them in writing at that time, and then later there's some issue where people forget what they agreed on, or they decide to change their mind, or they don't agree on it, and it creates problems down the line to the point where sometimes the songs become unusable because the splits can't get worked out and there's a contractual problem.
And if there is a problem down the road and someone says or feels that their song has been plagiarized, copied, or used in an unauthorized way, what can they actually do to take action about that?
Well, I'm not a litigator, so I'm the person that drafts and negotiates and reviews the contracts and advises. I don't do the infringement suits, but what happens at that point is hopefully that person has a federal copyright registration so that they are able to sue for infringement if they need to. But what a court looks to mostly is substantial similarity and access. So they will look at the similarity of the songs and they will look at the access to that song. So for example, are you just saying that so-and-so famous person infringed your song when they've never heard it, or was there actually some evidence that you sent them their song, that you worked together, that you worked with a producer that now worked with them, something along those lines where they actually had an opportunity to hear your song?
I see. So it's not all just the similarity. It's access is a factor as well.
Yeah, that's a factor, and that's been, for example, in the recent case with Led Zeppelin, where Stairway to Heaven was accused of infringing another song. They said, well, the band that was suing Led Zeppelin and Led Zeppelin had been on a tour together in the 70s, so that was their access, that they had opportunity to hear that song at that time. So because there is something called independent creation, and two people can independently create something that sounds similar without ever hearing it from each other, but usually it's not going to be an infringement. Like if you wrote a song and then I wrote a song and you said my song infringed on yours, if I'd never heard your song, how would I have copied yours, right? So that's basically the breakdown of how it works.
Makes a lot of sense. Okay, we don't want to hold you up much longer. Erin's off to give a course. We're here at NAMM, so thank you very much for your time. We really appreciate it, and have a great course.
Thank you very much. And if anybody needs more information, my website is themusicindusтрylawyer.com and indieartistresource.com.
Take care.